what people want to understand. The election petition by President Mahama is pursuant to, they say, Article 64 of the Constitution. Then there was some rules manual, election manual, developed by the courts under constitutional instrument CI 99. And now, President Mahama begins the process, the MPP responds. What is the latest? So that we want people to really understand. We understand that the proceedings might stop or something like that. What are the various applications that have been filed? What has been the court's responses? We will show the timetable that you gave us on screen so people can see it. Okay. But where are we?
Okay, Paul, before I proceed to where are we, I need to, you mentioned that there was a manual that was developed, which is factually correct. Yeah. However, the manual was not developed in accordance with CI 99, before every election, 2012, before the election, a manual was developed, and that's something the Judicial Service does all the time. And in 2016 to 2020 election, 2016 it was done, 2020 election too, same was done. But what has brought the confusion is the issue relating to CI 99, which has been introduced into it, which I don't think there is much confusion about it because the rules have been quite clear, been started. The rules on election petition, if you look at the history, started with CI 16. So in CI 16, as far as 1996, it was allowed, and you see Justice IKR ban, and at that time, the Attorney General at that time was Obeda Samoa. They passed CI 16, and there was a provision for that. Then, at that time, we didn't have presidential election, litigation. Then we proceed to 2012, where CI 74 was introduced into it. And CI 74 introduced into it, it allowed for abridgment of time, among other things. Then election 2012 came, then petition followed. And after that, Bimpombuta actually wrote in his book, when he published the Supreme Court of Ghana Law Report Special Edition, he talked about certain reforms which was adopted in CI 99. So it's in accordance with this that the election petition process started, petition filed, answer delivered, and after answer was delivered, mistakes were found by the petitioner, amendment was prayed for, it was granted. Before trial could start, the petitioner's lawyers, Mr. Tonilita, who's the lawyer on the record, decided to apply the tools that most lawyers do apply when it comes to...
I hope you can hear you well in spite of your mask, unless...
I'm okay. I don't know if it's clear.
Okay, I hope so. They will signal me if it's not too clear.
Okay, yeah. Okay, that's fine. So they then applied the rules. They started with filing to request to admit certain facts. They proceeded to file...
Now, say that again. So they filed, President Mahama filed his petition.
Yes.
Then he amended it.
Yes.
To make some corrections.
After Mahama filed his petition, the first and second respondent filed an appearance. And after they filed an appearance, they proceeded to file an answer to the petition in accordance with it.
So appearance means what?
Appearance means definitely you notifying the court that you are in receipt of the petition. And for that matter, these are my lawyers. In case you want to serve me to any process, these are the people that you serve me through. And that was done by Akoto Ampao for the second respondent and Justin Manuel for the first respondent. Okay, so President Mahama files, and then the President and the Electoral Commissioner also file appearance and their responses. Yes.
Okay, what happened after that?
After they filed same, President Mahama's lawyer, through his lawyers, filed an application for an amendment of their petition on grounds that they have seen certain errors, which was opposed to by both respondents, and the court listened to it and granted it. And after that, they filed the amended petition. Okay, so the first application that President Mahama made to the court was granted. Was granted. Which was for him to correct errors on his document. Yes. That was granted. Yeah, that was granted. But although that same was opposed. But why? You're a practicing lawyer. Why did they oppose something like that? Well, in the nature of litigation, the lawyers, as part of their strategies, are entitled to oppose it if they disagree with the party that has filed it, and that's permissible. Because remember that in every application, you are seeking a prayer from the court, and the court can decide whether to grant it or not. So I am entitled to oppose. And if you remember the history of election petition, in 2012, every single application was opposed. And that tells you that the stakes are high when it comes to such litigation. Okay, so that opposition failed. President Mahama was allowed to correct the errors. Yes. Then what happened after that? Then after that, President Mahama proceeded to file an amendment as ordered by the court. Nanado also filed an amended answer to same. EC did not file an amendment. It's understandable because they didn't feel their answer needed to be amended anyway, pursuant to the amendment that was done. And after that, President Mahama's lawyers decided to file a request to admit certain facts, which they laid out in their process, and filed a process called application for leave to serve the Electoral Commission interrogatories, i.e. certain questions that they think are very relevant for it to be answered, so that it will aid and facilitate speedy and effective justice in the trial process, which was opposed by the EC lawyers. And at that time, the application came on, same was moved, opposed, the court refused the application to serve interrogatories.
So those interrogatories are the 12 questions that,
yes,
that were published in the media.
Yes.
And President Mahama filed to ask permission to get the Electoral Commission, yes, to answer those questions. Yes. And the court says no.
Yes.
On what basis?
Okay, so first of all, in terms of the history again, and it's very important that we understand where we are coming from so that we get to know why the court might have taken the decision that it took. Now, we do understand that when it comes to trials, the courts that are, which have original jurisdiction to determine civil and criminal matters, are basically the High Court and the other lower courts. They have the original jurisdiction to them. When it comes to the Supreme Court first, as a court of first instance in terms of trial, is mostly seen in election petition. In appeals, maybe when you want to call in fresh evidence. So in the Supreme Court, the rules when it comes to trial is not as detailed as compared to the High Court rules. So if you look at the High Court rules, the High Court rules clearly tells you, the 1 Rule 2 that, the 1 Rule 1 wants that the rules are applicable to the High Court. But when it comes to the Supreme Court rules, the rules also says that there are certain matters which is not taken care of by the rules. And based on our history, when in 2012, certain matters were not taken care of by our rules, we fell on CI 47 for it to be done. But the court now says that based on the ruling that it came up, but that there's a new legal regime, which is CI 99, which is an amendment to CI 16. And for that matter, when those CI 99 regime has kicked in, it does not allow for those processes like interrogatories to be done, as was done in 2012. That was the decision of the court.
Okay, so the NDC people were saying something that whilst those questions called interrogatories were allowed in 2013's petition, yes, it was not allowed here. And you explained that the Supreme Court is able to do that. Yes. But in the ruling, the Chief Justice said that Mr. Tsikata, who filed these things for President Mahama, had failed the test of relevance. What does that mean?
Well, in terms of the court making a determination of interrogatories, just like any other process, the court will consider it on its merit and decide whether they think that is relevant to what is at stake. And the court disagreed that in terms of the question that they are seeking to answer, they didn't think that at this point in time it's relevant based on the legal regime that has been set up.
I see. So the relevance test was failed.
Yes.
Then what happened after that?
So after that, Mr. Tsikata, Mahama, who is the petitioner and instructed his lawyer that he agrees with the position of the court, they have filed an application to review, seeking a review of the decision of the Supreme Court. And it's very important to mention that when it comes to the decision of the Supreme Court, when the court takes a decision, you don't appeal it. You can seek a review. But the interesting bit of the CI-99 now brings in the CI-74, which has not been repealed, now says that when it comes to the final decision of the court, you cannot even seek a review of same. So there are certain people who said a school of thought whether or not the court will be willing to, has even jurisdiction to hear a review matter. But it's supposed to be also mentioned that the Constitution grants a review when it comes to the Supreme Court making a decision. You can seek a review of same, which is returnable at a future date somewhere next week. So that's what that
was an issue. Yeah. Mr. Tsikata and President Mahama's lawyers were concerned that the date for the review is being put beyond the beginning of the trial.
Yes. Yeah. Because you see, people should understand that when it comes to Mr. Tsikata's client is John Mahama. Although the entire country, Ghana, has an interest, he has a duty as an officer of the court to protect the interests of his client to the best of his abilities. And for that matter, it's also understood that the other side will also disagree because they also have to protect their interests. And the court as an umpire will make a decision on same. So they took the view that once we have a review motion which is pending, we think that it is very core in terms of our witness statement or decision that we will make before we file it. So we think that the court should hear our review process before we proceed to trial. And that's where the court felt that in terms of what the new legal regime is about speedy and effective justice, because it's very important to know that when it came to CI 74, which was the regime in 2012, it allowed for abridgment and extension of time. But it was repealed when it came to CI 99. So you could clearly see the thinking of the court that, this is a matter that we need to finish up with it. And when you do read the court's inspiration, when they took that of Kenya, in Kenya, the constitution actually says that you have to finish the trial within 14 days.
That's what the Kenyan Constitution,
the Constitution says.
Election petition must be completed
in 14 days.
2 weeks.
2 weeks. And that's what happened.
But you see, in Kenya, is it not the case that whilst during the pendency of the election petition, you cannot swear in the president? So that means we are able to swear in the president.
Yes. But I'm saying that in all of it, it's about the framers of the rules understanding that there is an urgency to this particular matter. And it is not for the fun of it that the rules has been made, it was made in CI 16 came, CI 74 came, and the framers of the rules decided to even take out the portion on abridgment of time. And what is also important to notice that when it comes to how the rules have been structured, the rules actually say that you are debarred from further proceeding with the matter if you fail to comply with an order of the court, and unless you seek the leave of the court. And I think that it will come into bear when the court sits on Tuesday to hear the stay of proceedings that has been filed by John Mahama's lawyers, pending the determination of this review application on Thursday.
So this interrogatories was failed.
Yes.
And now he's filed an application for stay of proceedings.
He first filed an application for review of the ruling of the
one, yes. And the review date has been given.
Yes.
Mr. Tsikata
Which is the 28th.
The date is too far. That's what he thinks.
No, Mr. Tsikata, they don't say the date is too far. Mr. Tsikata's position is that, in their respectful opinion, because the review, if the court so decide, because in review, the panel has to be increased to 9.
So from 7 to 9.
7 to 9.
But all 7 judges thought that they should not allow these questions for the Electoral Commission because it's failed the test of relevance, etc., etc. Now, in review, 2 more judges will be added.
Yes.
To the 7 or another 7.
To the 7. No, the same 7. Yes.
And they will hear it again.
They will not. Review has always been said. It's not an appeal. They won't allow for legal arguments. So it's a very narrow window that you have to point a point of law that you think the court has made a mistake on saying, for which the court would then make a decision whether or not they would reverse this decision that it made.
So as you say, it's a narrow window.
Yes.
But Mr. Tsikata wants the review heard. He wants it to be heard.
Yes.
Before the case continues.
Yes.
When will that happen?
The review motion is for the 28th of January, but the stay of proceedings is for Tuesday, which is the 26th.
Oh, so on Tuesday, instead of what has already been planned,
yes,
the stay of proceedings argument will be heard.
Yes, that's the 10 day that the registry has given.
And you expect that the other side will oppose the stay of proceedings?
Based on precedents, of course they would.
They will.
Based on because as I told you, in 2012, and 2012 affidavit in opposition was so much that the number of rulings that the court had to give actually considered one law report. So that's how to give you an idea. Yeah. That there was a 2013 edition, Supreme Court of Ghana law report of 2013 edition, solely dedicated to the election petition rulings and judgment. So it tells you once the stakes are high, definitely people are going to oppose.
If the court rules, the court will rule one way or the other on Tuesday. Yes. Over whether to stay their proceedings or to continue.
Yes, most likely.
If they were to rule that the proceedings should continue, that is to say the application for stay of proceedings fails, what will happen?
It will be interesting to see what the court will do. Because remember that in terms of filing of the witness statement, the court made the filing of the respondent's witness statement as a condition, the condition precedent before they can file their witness statement is after the petition has filed. And once the condition has not been satisfied, it is it's not possible for the respondents to file.
We want to understand what is a witness statement, but if you have the document of the trial of the court, can you please put it on the TV now? Let Dennis take our viewers through it so we can understand clearly. So there you are. So Dennis, that's it. So 01 is what?
Okay, so we have it. So so if you look at the decision that the mode of trial that the court, so 01 is basically the court saying that by the 21st, the petitioner has to file his witness statement and attach exhibits.
Okay, so that we have done that already.
No, that has not been done.
Okay, so by the 21st of January, petitioner must file
the
witness statement by today.
Yes.
What is witness statement?
Witness statement is basically what we used to call examination in chief, where you go into the box as a witness. You bring your witness. Your witness has to now put everything that he will say on paper, as compared to at first, where the person will go into the dock and will swear and orally give his testimony. But now the court
so he has to write. So if it's 35 pages, he has to write it.
He has to write everything. Yes, that's not a
like write it. So I, Paul Adom-Otchere, I will be saying that I was to do the constituency.
Yes, so everything that you are supposed to state orally, you are supposed to put on paper.
I see.
Yes, and then when you come...
And I sign it.
You sign it, yes.
So President Mahama said he intends to call 6 witnesses.
Yes, so
he must file 6 witness statements.
Yes, all the witnesses, I said 5, all the 5 witnesses must put, if they intend so to call, must put their statement on paper.
Is he one of the 5?
I don't know, it depends on the strategy.
Could he be?
He could, or he could
but
decide to nominate.
He said he intends to call 5 witnesses.
Yes.
That means he's not one of them. Or it doesn't mean that.
No, so when usually the representative, the person in the party is not deemed as a witness. So that's why you have the party as the main representative. And after that, there's PW1, that's a witness 1, witness 2. But nothing prevents a party to decide that he will not participate in the hearing. Depend on the facts, the evidence on record. Because you, as a witness, you should be privileged to have primary evidence. You should be able to understand what you're about to testify to. So if he thinks that somebody else will be in a better position to testify for his case, why not? He's not compelled.
So it's not automatic that President Mahama will be in the witness box?
Yes, 2012.
As Dr. Baumia was?
Yes, 2012, Denado was a party, Denado was not.
Yeah, but in 2012, Dr. Baumia was a petitioner.
Agreed.
In this case, President Mahama is the only petitioner.
Agreed.
So...
because the rules have changed.
Yeah, the rules have changed. Does the rule say that the petitioner must be?
No.
It doesn't?
It does not. And even in all that jurisdiction, at the end of the day, it's your case. How do you want to make out your case is dependent on you. But bear in mind that the witness has a threshold in terms of credibility of the witness, okay, because his credibility will be tested. His ability to recollect events, it will also be tested. And so there are certain events, there are certain people who have bought lands, and just to straight away, certain people who have bought lands in Accra, they themselves were not the one who followed it up. There may be an agent who might have gone on the ground, knows the history of the land better than them. So in terms of trial, instead for them to go and testify, and they do not have any appreciation of how the land, the history of the land, they prefer to put their agent in.
So today, the President Mahama said we're expected to file all the 5 witness statements. Yeah. And that didn't happen, or do you know that it happened? Or it
didn't happen, because they have filed a stay of proceedings.
Ah, yes. So after they file, let's go back to the calendar and see how we go through it. Let's put the calendar back on TV. Okay, so there it is. So 21st is today, that is the petitioner to file the witness statement. Yes. Okay, then 02 is what?
02 is supposed to be the respondent. So after that, the respondent, i.e. both the EC and Denado, are supposed to file also their witness statement.
Their witness statement.
After they have been served with the petitioner witness statement.
Oh, that's one day, 21, 22.
Yes, yes.
So they also write everything
so
that...
So that's the point I just made, that once they have the condition precedent in terms of they filing their witness statement was for them to have been served with the petitioner's witness statement. That is the direction of the court. And once I've not been served, they can make the case that, because I've not been served, that's why I didn't file my witness. But there are instances where people say that because I understand my case strategy, I prefer to file my witness statement.
I see. So how many witnesses will President Akufo-Addo be calling?
It depends on...
they haven't said?
They have notified, I think about 3 or 4. But as I said, what I do know is that some of these things, in terms of, a practitioner, you prefer to state a large number than a short number. Okay. So that in case you need all these people, you can put it in. In case if you go lower, you are not.
So you can file. You can say that I will be using 3 witnesses.
Yes.
But in the eventual analysis, you call 2.
Yes.
But all 3 witnesses must file their witness statement.
All 2 witnesses.
So the one that you don't want to use, you tell the court, I don't intend to rely on it.
Yes.
Ah, I see. Let's talk about the Electoral Commission. They will also file a witness statement.
Yes.
Must the chairperson of the Electoral Commission herself necessarily be a witness of the EC?
No.
Can the petitioner's lawyers, Mr. Tsikata, call that she comes for examination?
If the court, if you can subpoena a witness.
That's what I'm asking.
Yes.
So can they subpoena her?
You can see.
The subpoena is done by the court. So you apply to the court to subpoena her.
So those are the confusion that is coming in. And then some of us are of the school of thought that we think it's time that election petition must have its own rules, detailed rules, than this approach where we seek to sometimes borrow from the High Court in order to supplement it. Because if you look strictly at CI 99, the rule on subpoenas is not permissible in it. But in trial, subpoenas have always been part of the practice of the court.
CI 99 does not permit subpoenas?
No.
In that case, the Electoral Commissioner cannot be subpoenaed.
And that's what I'm saying, that it depends. At the end of the day, what will the court say? Because people held the view that, although it was expressly stated that amendment of grounds are really not permitted, the court was flexible to give. Because bear in mind, at the end of the day, it's about the rules of the court are being made to ensure that speedy and effective justice is achieved. So if the court in its wisdom think that it is relevant for us justice to be achieved by applying these rules, the court will permit, say. But for now, I think that the nature of the rules that have been structured, and if you look at where we are coming from, the court will not allow any process that will seek to delay it in terms of trying to finish within the 42-day mandate as enshrined in the rules.
So we don't know whether Jean Mensah will have to appear. The court will decide on that. If they file their witness statement and it's not her, it's the director of elections, it's a bossman, the deputy director, and all of that, then that's what it will be.
Yes.
Okay. And President Akufo-Addo, is there a window for him to appear in the court?
If he wants to testify, why not?
Oh, he can?
Yes. He's a party in the suit.
But Alhaji Muhammadu Bawumia is not a party to the suit?
No. Because now
President Akufo-Addo is the only one who has been sued.
Because the rules have now said that the only two people you can sue, the people who has actually qualified to challenge the election result are those who lost in the elections. The people who are supposed to sue them is the EC and the one who won. The rules have made it clear.
I see.
So if you if you cannot be a petitioner, although the constitution says a citizen of Ghana can challenge it, they have now been interpreted in it, and they picked the Bimpomota's position that the proposed approach of a citizen of Ghana should be restricted to the citizen of Ghana who participated in the election. And that's how come it's only John Mahama.
Actually, it doesn't even go beyond that, where they say the person who believes that he won the election. So that Ikuya Donko cannot file an election petition.
The rules also say that. So they can consolidate suit if Ikuya Donko seeks to challenge it.
But Ikuya Donko can file. Because the manual that we read said that the person who believes that he should have won the election. Being the person who thinks he should have won, not one who got 1%, 2%.
But not necessarily. It's just that the rules have now been restricted that at first, if you look at the language of the Constitution, it's about citizens of Ghana. But the interpretation and the rules that are now made that when it comes to the citizen who is qualified to present the petition is the one who might have lost.
I see. Okay, excellent. So what happens after that, after the witness statements have been filed?
After the witness statement, if you look at the timeline that they have given, they expect...
Let's go back to the timetable and then we look at it. Let's go back to the timetable. They'll put it up in a minute.
Okay.
Yes,
so the third one, I think we missed the date. The third one is also 22nd. So they expect, because remember that the EC, with the first respondent, the second respondent has raised a preliminary legal objection. And the court has directed that they have to file their arguments by Friday, which is tomorrow. Okay, and they have to file their arguments, and they have to serve their arguments on the petitioner. The petitioner has, by Monday, to also file his arguments in response to same. So that's what you see. And they will come back to court on Tuesday for hearing to commence. And the court has directed that their ruling on the preliminary legal objection will be part of their judgment when they will deliver. I see.
Yes. So now that all these things have not been done, what kind of happens?
Now, in view of the stay of proceedings that has happened, that has been filed, the effect sometimes of stay is to hold on till the stay application is determined. But Paul, the interesting bit, as I said, is the language of the rule and of Rule 79 of the Supreme Court. And Paul, for our readers' purpose, if I may read it, and I think that's the first hurdle that Mr. Tsikata will have to cross in case he wants to bring the court's attention. And Rule 79 says that where a party to any proceedings before the court fails to comply with any provisions of these rules, or with the terms of any other or direction given, or with any rule of practice or procedure directed or determined by the court, the failure to comply shall be a bar to further prosecution of proceedings unless the court considers that the non-compliance should be waived.
That's interesting.
So what it means is that if the court gives direction, if the court makes orders, which it has done in terms of how the trial should go, if you fail to comply, it shall be a bar. It means that you are stopped from further proceeding with your matter, unless the court in its wisdom says that I've waived your non-compliance with my order in the interest of speedy and effective justice. I want to hear the matter. So once you decide not to comply with the order or direction of the court, the rules actually say that portion. And it's important to mention that CI 99 decided to amend the portion on election petition, but other provisions relating to the rules are still applicable. And Rule 79 is still applicable in this instance.
What you're saying is very interesting. You're saying from Rule 79 that the fact that they have missed the period of the time of filing their witness statements could count as a bar for the rest of their matter.
Yes.
They will be asked to go home.
That's what the court is saying. Unless you pray the court to waive your non-compliance. Because at the end of the day, is it a fact that in terms of what the court said, was it an order of the court? Was it a direction given by the court? If the answer is yes, have you complied with the order of the court? Have you complied with the direction of the court? If the answer is no, the rule says that you are barred from further proceedings unless the court waives it. And the court will look at the interest of, in this matter, the court will look at the interest of justice and decide to do it. But always we should bear in mind where we are coming from, that the rules on procedure becomes tighter as you climb the ladder. In the High Court and the district, when you don't comply with the rules, the rule actually tells you that it's an irregularity. And somebody can take a fresh step. But when it comes to the Court of Appeal and the Supreme Court, the rule says that if you don't comply with it, unless the court waives it, you cannot proceed with your matter. So it becomes tighter as we go up.
Okay, so where we are now, we have to wait for Tuesday.
Yes.
And see what the court says about all of that.
Yes.
So on Tuesday, the court will comment on the non-compliance of the timetable.
What is before the court on Tuesday is for the stay of proceedings.
Yeah, but will it comment on that as well? Do you know?
Maybe the court might comment. I'm not sure. Maybe the court will comment on same. Because you remember that Mr. Tsikata's position has been that they felt the court should have commented on the processes that they have filed. Remember, they have filed notice to inspect some documents.
Yes.
They have filed a request to admit facts. Based on the fact that they have made a determination of the it makes in their respectful opinion, it makes their request to admit fact and that of their inspecting of documents becomes a little bit hanging. And that's what they wanted those clarity on say. But I think on Tuesday, the court will give a direction on what to go. But bear in mind that the court wants to fulfill its mandate under the rules of speedy and effective justice, i.e., how best can we achieve and complete this process within 42 days, as has been mandated by the rules.
But by Tuesday, we are behind 42 days, aren't we? Okay, they have a long time to write their judgment, so they will probably have a shorter time to write their judgment.
No, but it's just that, is it possible? We have always had this discussion whether we can meet the 42-day rule. The court wants to meet it. It might be challenging looking at where we are and look at the process that are coming. But it all depends on the.
But we are definitely not going all the way to August.
Of course. The rules does not allow us to go back all the way to August, and both parties and their lawyers are aware that the rules does not allow that, and especially when you have, at first, in terms of CI 74, where there was an allowance in the rules for abridgment of time and extension of time, and that provision has been repealed, it quite clearly gives you an idea or the intention of the framers of the rules that we don't even want an opportunity for lawyers to do one of those things or even asking for extension of time. We want to ensure that we go by the strict timelines.
I see. That's interesting. Okay, so we leave everything until Tuesday.
Yes.
And see what happens. There's another small matter. I don't know whether you want to comment on it, given your professional matters about the way you practicing lawyers behave. Dominic Ayini, your senior at the bar,
yes,
came up for some criticism, and it's been on the media. What was it about?
I don't know whether you are making a reference to what happened in court.
Yes, I'm making a reference to what happened where the media reports that Dominic Ayini apologizes, and it is reported that the Lord Chief Justice had occasion to comment about gestures and something like that. What was it?
Well, first of all, most respected Dominic Ayini, I don't think that he will intentionally do anything to disrespect the court. Secondly, when you're a lawyer, it matters not where you find yourself. You are an officer of the court. Either you're in the courtroom or outside the courtroom. That's how come lawyers can sometimes even be sanctioned by their conduct that they did not do in the course of the courtroom. Mm-hmm. So if the court in its...
So that for the testimony that you are giving here in this interview, you could be sanctioned by the court.
If as an officer of the court, if I forget and I decide to do certain things unloyally, which seeks to affect my ethics of a profession, of course I can be sanctioned. Mm-hmm. And so if the court is of the opinion that a certain conduct of a lawyer is untoward in terms of his gestures that he made, and most important, the lawyer, I did not see it, the lawyer has also apologized for the conduct, and what is done, which is not strange. Sometimes you do certain things in terms of the heat of the moment. There are certain statements that we make against ourselves as counsel. We apologize to the court, and that's the humility of the profession. At the end of the day, you give credence to the court. You always want to maintain the sanctity of the court. And I think that was what happened that day.